Thank you very much. I would like first to thank the Intergovernmental Committee for inviting me to say some words in this panel, and I would like to also thank the Indigenous representatives and representatives of local communities who are here, who can also make use of whatever points I'd like to say to further push for their issues here in this Intergovernmental Committee. I have been a part of this Intergovernmental Committee meetings in the early years of its formation, and we put many of the key issues which we thought should be dealt with by this body. So coming back after more than 10 years reminds me of those early years of the debate, and I am quite pleased to see that the consolidated document relating to intellectual property and genetic resources still reflects the issues we raised in those early years. I welcome the resumption of the work of the IGC after a year's hiatus, and I congratulate the WIPO member states who displayed remarkable political will in enabling the renewal of the mandate of the Intergovernmental Committee and adopting a work program for this biennium. I regret, though, that the consolidated document still remains in that state and that this has not been considered favorably at the General Assembly. Nevertheless, we are all here and we should start working again and picking up from all the many years of work that this Intergovernmental Committee has done. I know for a fact that the work of this Intergovernmental Committee is under keen scrutiny, and the results of the negotiations are eagerly being awaited by other related processes which have been proceeding more quickly with their work on access to genetic resources and the sharing of benefits arising from their use. Among such bodies are the Nagoya Protocol on Access and Benefit Sharing, the Convention on Biological Diversity, the International Treaty on Plant Genetic Resources for Food and Agriculture, and the FAO's Commission on Genetic Resources for Food and Agriculture, the World Health Organization, among others. There are also recent decisions reached in other intergovernmental bodies which reinforce further the importance of recognizing rights of indigenous peoples and their important contributions, particularly the contributions from their traditional knowledge in addressing the global environment and development crisis. The Paris Agreement, which was agreed upon in the 20th Conference of Parties of the Climate Change Convention, now contains references to rights of indigenous peoples in the importance of traditional knowledge. You might be aware that at the 16th Conference of Parties of these same bodies, the Cancun decisions included the need to respect the rights and traditional knowledge of indigenous peoples and local communities in the forest and climate-related decisions. Now, during the Conference of Parties in Paris last year, December of last year, there's a big group of indigenous people's representatives, as well as several rapporteurs, special rapporteurs, including myself, the Special Rapporteur in Environment, and representatives of the Office of the High Commissioner on Human Rights, who were there in the in Paris to make sure that the references to human rights are also going to be included in the decisions of this historic agreement that was finally concluded in Paris. So with that participation, we managed to get some paragraphs on these issues that were reflected in this Paris decision. For instance, the preambular paragraph 8 of the Paris Agreement links the need to respect, promote, and consider the respective obligations of parties on human rights, and the list of rights mentioned included indigenous peoples' rights. Additionally, paragraph 136 of this Paris Agreement states, and I quote, recognizes the need to strengthen knowledge, technologies, practices, and efforts of local communities and indigenous peoples related to addressing and responding to climate change, and establishes a platform for the exchange of experiences and sharing of best practices on mitigation and adaptation in a holistic and integrated manner. You might not think that this is related to what is being done here in the Intergovernmental Committee, but I argue that this is very closely related because the contributions of indigenous peoples, their traditional knowledge systems, as well as their associated knowledge related to genetic resources, are very much relevant to these decisions. The other development that you might all know is, of course, the adoption of the Sustainable Development Goals, which was adopted by the General Assembly last year. This will serve as the main framework to pursue development between 2015 to 2030. And in this document, they also recognize that indigenous peoples are among those who have to be empowered so that the pursuit of sustainable development goals will impact on them positively, and the contributions that they can also provide in obtaining and achieving these goals are as well recognized. The document also clearly recognized the importance of the need to respect human rights. Paragraph 8 of the Sustainable Development Goals Outcome document, which is entitled Transforming Our World, the 2030 Agenda for Sustainable Development, says, and I quote, "We envisage a world of universal respect for human rights and human dignity, the rule of law, justice, equality, and non-discrimination, of respect for race, ethnicity, and cultural diversity, and of equal opportunity permitting the full realization of human potential and contributing to shared prosperity." So we are pleased that these references are there because this again reinforces the point that indigenous peoples have been bringing to this Intergovernmental Committee in terms of pushing for the need to respect their rights, including, of course, their intellectual property rights and their right to development. Furthermore, in compliance with the Nagoya Protocol, indigenous peoples are strengthening their customary laws and documenting their community protocols in order to put others on notice regarding rules for access to their genetic resources and clarify benefit sharing mechanisms. These protocols are also intended to form part of the compliance regime for legally binding instruments that they hope the WIPO will adopt for the protection of indigenous peoples' traditional knowledge. Meanwhile, misappropriation of the genetic resources and associated traditional knowledge of indigenous peoples continues unabated, and indigenous peoples are put in a difficult situation of tracking and prosecuting cases of misappropriation of their knowledge. It is in this light that I urge WIPO member states to speedily conclude the Intergovernmental Committee negotiations and adopt a legally binding treaty that would provide effective protections for the rights of indigenous peoples and local communities over their genetic resources, traditional knowledge, and traditional cultural expressions. As the independent expert of the UN Human Rights Council, focusing on the rights of indigenous peoples, it is within my mandate to provide an analysis of the human rights of indigenous peoples to their genetic resources, traditional knowledge, and related intellectual creations. In doing this, I will be building on the work of my predecessor, Professor James Anaya, who has presented his views to the IGC several times in the past. Mr. Anaya also has authorized a technical review provided as one of the documents for this session, and I urge everyone to read this important document. He reiterated in his technical review a key point which I believe we should all bear in mind as the negotiations under the Intergovernmental Committee are pursued. I quote part of his report which says, and I quote, "As part of the right to self-determination, Indigenous peoples have the right to autonomy or self-government in matters relating to their internal and local affairs. This right necessarily implies a right of indigenous peoples to manage and regulate the use of their genetic resources, traditional knowledge, and cultural expressions in accordance with their own customs, laws, and traditions. An important component of indigenous peoples' control over their resources and aspects of their cultural heritage is the right to determine to what extent and under what conditions such subject matter can be accessed and used by others, unquote. Article 31 of the UN Declaration on the Rights of Indigenous Peoples clearly sets out the substance of the rights of indigenous peoples over their traditional knowledge, natural resources, and other cultural property. And just to remind us again of what this contains, it says, indigenous peoples have the right to maintain, control, protect, and develop their cultural heritage, traditional knowledge, and traditional cultural expressions, as well as the manifestations of their sciences, technologies, and cultures, including human and genetic resources, seeds, medicines, knowledge of the properties of fauna and flora, oral traditions, literatures, designs, sports, and traditional games and visual and performing arts. They also have the right to maintain, control, protect, and develop their intellectual property over such cultural heritage, traditional knowledge, and traditional cultural expressions. Paragraph 2 of this declaration states, in conjunction with indigenous peoples, states shall take effective measures to recognize and protect the exercise of these rights. Other related provisions clarify that indigenous peoples are owners of natural resources within their territories and that they have the right to give or withhold their consent on the use of such resources, and this includes genetic resources. This article, Article 21, I know this by heart because I together with Matthias Aren, were one of those who were pushing very hard for the adoption of this article. We were very much involved in formulating the article, and I remember clearly the arguments that were put by a few governments who were not particularly happy about this article. Even amongst us, indigenous peoples, we also had a lot of debates because we had to debate whether we would use the terms intellectual property. I, for one, was one of those who felt that we shouldn't use it because of the very loaded context wherein this whole concept has been developed. But in the end, I was outvoted by the Indigenous caucus. So in the end, we did agree to include the terms intellectual property in the article. This is just to remind you that, and to recall with you that these debates have really been debated very extensively amongst indigenous peoples' representatives, both at the global level, but also at the national level. And one of the reasons why we actually finally agreed to have that there was one of our colleagues from Panama pleaded with us and said, you know, we really fought very hard for a law in Panama which includes the respect for the intellectual property of indigenous peoples. And if we don't find the words, you know, intellectual property in the UN Declaration, that might compromise or undermine the national law which we finally got in Panama. So that was one of the points which convinced us that, okay, then maybe we need to do that, but we always have to qualify exactly what intellectual property is and the broader understanding of this particular concept. Article 42 of the UN Declaration requires the United Nations, its bodies and specialized agencies to promote respect for and full application of the UN Declaration on the Rights of Indigenous Peoples. This means that WIPO has the obligation to fully implement Article 31 and ensure the protection of indigenous peoples' rights to their traditional knowledge, traditional cultural expressions, and other intellectual creations. The jurisprudence and practice developed by various human rights bodies are contained in the technical review provided by Professor Anaya. Most of the member states of WIPO have endorsed the UN Declaration on the Rights of Indigenous Peoples and have undertaken, through various human rights mechanisms and bodies, to ensure the protection of the rights of indigenous peoples. It is not unreasonable for indigenous peoples, therefore, to expect these WIPO member states, through the IGC process, to develop treaties to protect their rights to their traditional knowledge. The proposal for a mandatory disclosure mechanism could provide an effective mechanism for protecting the rights of indigenous peoples to their genetic resources and additional and associated traditional knowledge. Such a mechanism should, of course, require disclosure of the origin of genetic resources and associated traditional knowledge, whether such resources and TK are from indigenous peoples' communities, as well as evidence of free prior informed consent and benefit sharing. Where indigenous peoples have decided to grant access to and allow the use of their genetic resources and traditional knowledge, it should be pointed out that after the expiration of the agreed terms of use, rights to the genetic resources and TK reverts back to indigenous peoples who own the knowledge and does not pass into the public domain. This is based on the right of indigenous peoples to permanent sovereignty over their natural resources, as well as international human rights instruments and standards. Negotiations within the Intergovernmental Committee have to recognize that there is a staggering amount of information on indigenous peoples' genetic resources and traditional knowledge that has been placed on databases, registers, publications, archives, libraries, gene banks, or otherwise made publicly available without the consent of indigenous peoples. Any instrument that the IGC adopts must take this into consideration and put in place an accessible mechanism for redress and repatriation. While databases and registers may provide defensive protection for indigenous peoples' genetic resources and associated traditional knowledge, indigenous peoples must be able to retain control over their information put into the databases and must be part of the management structure of such registers and databases. It is almost 16 years since the work of the IGC started, and almost 20 years since WIPO conducted its fact-finding missions to identify the intellectual property needs and expectations of traditional knowledge holders. I urge WIPO member states to seek creative solutions that would unblock the negotiations and enable a diplomatic conference within the next 2 years. In particular, the proposal for a graded approach that has emerged in recent years within the framework of the WIPO IGC is an interesting proposal that could potentially unblock the negotiations. Finally, the recognition of the right of indigenous peoples over genetic resources and traditional knowledge is part of their right to development. The CBD takes this approach when it recognizes that indigenous peoples have the right to benefit from the use of their genetic resources and TK so that they can continue to practice their conservation and sustainable use practices as well as their traditional livelihoods. In closing, I would like to point out that the flexibility of the intellectual property system has allowed it to adjust to the changing contexts and technologies, such as the advent of the internet and the demand that intellectual property system address the situation of the visually impaired. I believe the time is ripe for WIPO to once again exercise its flexibility by finally addressing the intellectual property needs and expectations of traditional knowledge holders through the adoption of a treaty that recognizes and protects the rights of indigenous peoples and local communities to their genetic resources and traditional knowledge. Thank you very much, Mr. Chair.